Hearing in the appeals, Cape Intermediate Limited against Dring.
My ladies, my lords, good morning. Can I start with who's here, or some of them? Robert Weir, Queen's Counsel, Jonathan Butters, Harry Sheehan, instructed by Harminder Baines at Lee Day for the forum. Jude Bunting, through the pain of his broken wrist, is behind us, instructed by Oliver Murphy, Reynolds, Porter, Chamberlain for the Media Lawyers Association, who are intervening with your permission. I'm here with Geraint Webb, Queen's Counsel, and James Williams. We're instructed by Jonathan Eisted and Ian Jones of Freshfields for Cape. You know there's an appeal and a cross appeal, but you also know we've decided we can just deal with it straightforwardly. I'll make my submissions, they'll make theirs. The intervener will make theirs, and I'll reply.
We have noticed that, and we're grateful to you. It seems to us, possibly a matter of chance who is the appellant and who is the respondent in this case. You're both equally dissatisfied with the Court of Appeal.
Nobody's happy.
Yep.
I'm going to introduce the case with three, I hope, brief parts, and then I've got submissions orally to make under 5 headings. When we come to that, I'm going to look at records of the court, the inherent jurisdiction informed by the open justice principle, those being the 2 main topics at this hearing. Then I'm going to look behind the scenes at what the committee has been doing, the Rules Committee, across the years, because they've had no fewer than 5 subcommittees that have looked at these issues. And it's quite illuminating to see what they made of it. Then I'm going to go around the world on the basis of all the materials that we've helpfully been given. And then,
are you going to Scotland?
I'm very happy to go to Scotland, if the court would like me to. There's an interesting case about contemporaneous reporting.
The reason that I ask, the point has been made that we are the United Kingdom Supreme Court.
Yes.
It is possible that the principles are, in this respect, are different in each part of the United Kingdom. But if so, we would like to know that they are different and why.
It's not my submission that they are. If somebody else is submitting that my logic is that they would be, then they can develop that. And I will...
Well, that's why I'm making the point at the outset. There are 1 or 2 other things we want to know as well. But
There'll be many things along the way, but if you're content for me to at least
start.
Plough
on.
Thank you. My lady, first the parties' positions, and we can do this by reference to the orders that were made below. You've got those in the appendix and, of course, in the electronic bundle. Let's start with the forum's position. They say the Master's order was correct. Now, she's at page 318 and 319 in the appendix. And as you know, she ordered at the bottom of 318 that permission be granted for the forum to obtain copies of documents from the records of the court, and then all the witness statements, experts' reports and transcripts of this 6-week hearing that, as you know, then ended in settlement. And D on page 319, disclosed documents relied on by the original parties at trial contained in the paper bundles only. That was the 17 lever arch files that were in 6 boxes because they were the judge's lever arch files that had been used at the trial. Then all the written submissions and skeleton arguments and the statements of case. And she then orders, as you see at paragraph 3, and they, as their primary case, say that this is correct and its basis is correct, that those documents be made available forthwith to the appellant solicitor for copying or scanning. So judges marked trial bundles, all 17 lever arch files over 5,000 pages, to be made available, take them away, scan them and upload them to the internet. She didn't order that they have access to Bundle D, though she did say it be preserved. Bundle D, you'll know, is the electronic 45,000 pages of disclosure documents. All these facts are set out in the Statement of Facts and Issues, paragraphs 6, 7 and 8 at page 99. And they had included within their claim transcripts. You'll see she orders on the previous page, paragraph 1, that transcripts be placed on the court file, so bypassing the rules about getting hold of transcripts. That's their position. In the statement of facts and issues, paragraphs 12, 15 and 17, you see that these claims, and we're only interested in the product liability claims, had been disposed of by an order of the 14th of March 2017. That's at page 938. And at 939, it involved order of a payment in full and final settlement with all further proceedings dismissed. So that's what had happened, and that's why the judge was functus. Then at paragraph 15, there's a restraining order that the master makes on the 6th of April 2017, ex parte. Two parts to that: application under CPR 5.4c, but an injunction against the parties, or the former parties, to restrain them. And at paragraph 17 of the Statement of Facts and Issues, you'll find as an agreed fact that the parties, page 102, 3 lines into paragraph 17, the parties to the product liability claims had not yet arranged to remove the trial bundles from the court. Thus, the judge's copies of the trial bundles for both sets of proceedings remained with the court. It is understood that the judge's trial bundles were taken to Master MacLeod's room. So that's what we're talking about. The Court of Appeal, as you know, decided that those bundles and materials are not within the records of the court. They held, though, that there was an inherent jurisdiction to allow access. They didn't say, and couldn't have been contemplating, given their holding about the records of the court, access of the judge's marked up and highlighted trial bundles. But in any event, we addressed them on this in the context of what order they should make. It's Appendix 1A, and it's electronic bundle, page 945. And we made the point that in the light of the logic of their judgment, the order that they were making, although we were going to challenge it, was a mandatory order against the non-party. That was disputed in submissions put in by the forum, but the Court of Appeal agreed with us because that's the order that they made. You'll see it at paragraph 7 near the top of page 945. This approach is the only one consistent with the court's judgment. That's the nature and the jurisdiction that you must have found they agreed. The intervener's position you can find by going straight to the end of Mr. Bunting's written case. At paragraph 40 to 42 on bundle page 219. 40 to 42. The substance is this. In a context, they say, paragraph 40, where the records of the court don't include the trial documents and the skeleton arguments, and where, as they rightly say, towards the end of that paragraph, 4 lines from the end, there are no central records of submissions and evidence in a case. And the preceding point is that skeleton arguments and evidence are marked up, and before that, the trial bundles are returned to the parties. So in those circumstances, their position is then paragraph 41. For open justice to be a reality, say the interveners, the media must be permitted to seek access to the evidence that was relevant to a court decision, especially where written evidence has taken the place of oral evidence and where that evidence has been taken into account by the court in making its decision. The media cannot fulfil its role as watchdog of justice if it cannot see the material relevant to the court's decision. 3 times there, they tell us that their position is about material relevant to a court decision. And in due course, we'll have a look at what they actually said when they were consulted by Lord Justice Richards for an open justice subcommittee of the Rules Committee about documents, because it is strikingly different. Anyway, that's their position when they're asking you to find that there is, as a matter of open justice, that jurisdiction, indeed, they would have to say that need, and they go on to say at 42 that the power is wide enough, 3 lines from the end, to permit a court. It must mean to require a court because we're in open justice and we must be into necessity, anyway, permit a court to require a party, that must mean former party, to provide the media with relevant evidence and submission. So a couple of footnotes about the intervener's position. Court decision, documents relevant to a court decision. Well, that's not this case. Where you have a court decision, of course, open justice can be evaluated in the light of the judgment. And judgments are given, and they are designed to be self-standing and informative, not just to parties, not just to appeal courts, but to everyone. Second footnote, the intervener on the previous page has included one paragraph on the Human Rights Act. The respondent includes no paragraphs on the Human Rights Act, and we made the point in our case that there is no issue as to the Human Rights Act. And that is a relevant point to note, because Parliament has conferred statutory human rights obligations, including in the context of NGOs and court proceedings. And in the bundles, there's a case. It's volume 17, tab 190. We don't just turn it up, I just tell you, it's a case where an NGO succeeds in Strasbourg on the basis that the lack of transparency from the Hungarian Constitutional Court meant that there had been an unjustified censorship from the NGO's position. And it's a 2011 case. And the short point is this: if, which I don't accept for a moment, if there were a basis in a case such as the present for an NGO to go before a domestic court and to say, we have an entitlement to greater transparency from this court, and that could be grounded in the human rights protection that Parliament has conferred, that's the argument that would be made, evaluated and decided. And of course I accept, subject only to rather difficult questions of horizontality, when you're looking at, yes, court is a public authority, but actually what order is being sought, against whom, to achieve what, subject to those rather difficult considerations, if there is an obligation on the court, the court will discharge it. Again, not this case, and rather striking that it must be common ground, that there is no such basis. In other words, whatever threshold it is that is applicable to that kind of issue as a matter of statutory human rights has not been reached. I'm not belittling the common law at all, but I make the point because we submit that it is relevant and it's striking. Thirdly, our position. Again, by reference to the orders that were made below, we say the Court of Appeal's paragraph 4 at page 225 of the electronic bundle was correct. The court shall, so far as they are on the court file and the prescribed copying fee is paid, provide the respondent with copies of the following documents from the court record: statements of case, further particulars. That's it. That is where it stops, we submit. And that is where it should have stopped. Yes, well, of course, we should have been entitled to see the previous paragraph.
Sorry, could you just give me the paragraph?
Yes, paragraph 4, my lord, on page 225.
Thank you.
To retrieve the bundles that had not yet been collected, and that's confirmed by the order at paragraph 3. So we challenge the wider order that the Court of Appeal then goes on to make in paragraphs 7 and 8 of its order. And in order to make sense of them, you've got to read it alongside the Court of Appeal's judgment, which I'll come to now. So Appendix 2, which is order of access, is page 227 and 11 items. It's the witness statement and experts' reports that stood as evidence in chief at the 6-week trial, and it's the skeleton arguments, written submissions, that were used for the trial. That we challenge. And then we challenge the satellite application remittal exercise that the Court of Appeal then identifies at paragraph 8. Listed for further hearing, trial judge if possible, if not another High Court judge, to determine whether there's any document, any other document that falls within the scope of Roman 2 and Roman 4. We'll look at those in just a moment. And if so, whether the court should, in the exercise of its inherent jurisdiction, require the appellant to provide a copy to the respondent of it, having regard to the factors in 127 and 129. So there's the mandatory order against the former party. Now, the Court of Appeal's judgment is in the appendix, but we sent it through to you from the law reports, and I'm really hoping that reached you.
Thank you very much.
If it didn't, I'm going to need to get a copy of the bundle version to put alongside me so that I can give you page numbers for those of you who are not looking at the law report. Is anyone in that position?
Did it reach us in electronic form?
Yes, it did.
But it's not in the actual principal?
No, because it was reported very recently.
Yep.
I'm sorry about that. If you've not got it, then I will give you paragraph numbers, and if you're able to locate the Court of Appeal's judgment, we won't have any difficulty. But I'm sorry, we thought it would be better for you at least to know about that. Sounds as if some of you do and some of you don't.
Well,
I'll give
I've got it
paragraph
in hard copy. But
If you've got it in hard copy, we'll be absolutely fine, because the only thing I haven't got at my fingertips is electronic numbers for every single paragraph, because I'm working from the law report. But it's not going to be a problem, I'm sure.
It was emailed.
Yes, it was.
And it just has its own information.
Yes, it does. So are we all either working from the law report or a hard copy of the Court of Appeal's judgment? If so, we're absolutely fine. We'll just do it by paragraphs. So categories Roman 2 and 4 you'll find at paragraph 112 in the Court of Appeal's judgment, where Lord Justice Hamblin for the court, paragraph 112, identifies in subparagraph 2, with this narrative, there's inherent jurisdiction to allow non-parties inspection. I emphasise inspection. At this point, he's talking about access. You can see it and read it. Later on, we get copies. Inspection of, and then witness statements and so on that have stood as evidence in chief. That we've seen goes into the list that is ordered. And then Roman 2 and Roman 4 is what we're interested in. Documents in relation to which confidentiality has been lost under 3122. Just pausing there, that's because the court looks through the prism of a rule that is to do with the implied undertaking, as it used to be called, and whether you've been released from it. I'll have something to say about whether that's the right prism. But they set that out at paragraph 101, and you'll know it very well, read to or by the court or referred to at a public hearing. So they're using that as the prism. And for Roman 2, what you need is a document in respect of which that is true, and which is either read out in open court, which the judge is invited to read in open court, which the judge is specifically invited to read outside court, or which it is clear or stated that the judge has read. In other words,
Those are additional hurdles,
yes,
which must be surmounted
Yes.
document by document.
yes, that's right. So it's 3122 plus the judge has read it, or heard it read in open court. That's category 2. And then category 4, on in the same paragraph, any specific document or documents which it is necessary for a non-party to inspect in order to meet the principle of open justice. Now, that must also be a through the prism, but this time without the added hurdle. And I say it's through the prism because of paragraph 110. Under the heading Other Documents Necessary to Meet the Principle of Open Justice, which is what turns into Roman 4, the court says, in any case there may be specific documents which don't fall within the categories identified above, and then this, in respect of which confidentiality has been lost under 3122, but notwithstanding inspection of all documents available and of the transcript, it is necessary for a non-party to inspect in order to meet the principle of open justice. So that's what's then summarised at Roman 4. So it comes to this. This time it's going to be documents not read by the judge, but referred to in open court. If they've been read by the judge, they're in Roman 2. Not read by the judge, but referred to in open court.
Well, not necessarily not read, but where it's not clear that he's read them.
Yes, I accept that.
Otherwise, the necessity is this rather odd kind.
Well, in my sense, it's odd anyway.
Necessity.
It's odd anyway. But, all right, not clear that the judge has read it, but referred to in open court. And then, which it is necessary for a non-party to inspect in order to meet the principle of open justice. And what's that mean? End of paragraph 110 gives us the answer to that. It will be so necessary where it is not possible for a reasonable observer to understand the trial evidence, argument or issues without inspection of the document or documents in question. I adopt that as a necessity test. That is the right necessity test if we're into a necessity test. Then you have the relevant likely factors. The way the court deals with this is they do it firstly under records of the court, Rule 5.4c. That's paragraph 127. The principles to be applied when you're getting copies under 5.4c. That's because Rule 5.4c entitles you to copies if either you don't need or you have the court's permission. And there are the factors then, the extent to which the open justice principle engaged, whether the documents are sought in the interests of open justice, whether there's a legitimate interest and so on and so forth, the reasons and the harm. And then at 128, they identify a likely to lean in favour of test, where the principle of open justice is engaged and the applicant has a legitimate interest. We'll come back to that, but that's all from the authorities which they set out. Dean and Pfizer Health. Dean, they quote in paragraph 120. And you'll see that's the principle, 119. Pfizer Health is 120. That principle is where the purpose is not to monitor that justice was done, but the documents have nevertheless been read. I'm reading the middle of paragraph 120 in Roman 4. The court should lean in favour of disclosure if there's a legitimate interest. That's very well established case law, that is how you approach the discretion to grant permission in relation to records of the court under 5.4c2. That's what they're discussing at 127 and 128. What they then say at 129, or Lord Justice Hamblin for the court says, is that where you've got the court's inherent jurisdiction, the factors relevant are likely to be those at 127, and then we get likely to lean in favour, where the applicant has a legitimate interest in inspecting the identified documents or class of documents. But we mustn't lose that necessity test. It's all about intelligibility or comprehension of the trial evidence, arguments and issues. Now, we say, because of course there's quite a lot of room between the positions taken by the parties in this case. There are various intermediate positions that you'll wish to consider. And so far as they are concerned, we say that if there is an intermediate position, which we don't accept for a moment, then it surely must be much simpler than the exercise which the Court of Appeal has laid out. And if you go back to the end of paragraph 112.2 to item 4, that was the category of documents which is necessary for a non-party to inspect in order to meet the principle of open justice. And the principle of open justice is the end of paragraph 110. Now, why on earth, we say, would it ever be wider than that? Because if it's an inherent jurisdiction driven by the open justice principle, because of constitutionality or fundamental rights, if they can be so characterised, it could not go beyond that which is necessary in order to meet the principle. And it certainly couldn't do so in the context of an elaborate and carefully constructed set of civil procedure rules. So that would be the only question, and the gateway would again be to look, first of all, whether the judge has read it or is taken to have read it, and then to ask that question. Just while we've got it, you'll see references in the Court of Appeal's analysis. A good example is at the end of paragraph 107, and again at the end of paragraph 108, to what would have happened when trials were conducted orally. Handle with care, we say. The idea that judges have documents and pre-read them goes back a very long way to before Scott and Scott, as we point out in our printed case, because Lord Shaw, who is always cited for this constitutional value, has discussed the ecclesiastical courts and discussed the fact that judges took bundles away and read them and came into court having done so. But
that rather leads on to a question which I'm throwing out at this stage, because it follows from what you said.
Yes, my lady.
Of course, Lord Shaw was referring to the practice of the ecclesiastical courts.
Yes, he was.
The Family Division, or the Probate, Divorce and Admiralty Division, of course adopted the practice. In fact, it was mandated to adopt the practice of the ecclesiastical courts. So that definitely includes pre-reading, but it also includes, these days, the retention of the bundle by the court.
Yes, well, some courts do, and I'll show you that in insolvency, there is a specific rule.
You mentioned that. Is there a specific family procedure?
I don't know, I'd have to check that.
Well, I think I'd like to know. I probably ought to know it already, but it's a long time since I was at the family.
Well, so should I, or we should have checked that, and we will. So trials conducted orally, what would have happened with trials conducted orally? Beware documents and pre-reading very long standing, people going and sitting in a court where the judge and others will have materials that those in the public gallery don't have. And one thinks back to witness trials that involve documents, contracts, deeds, wills, whatever document it might be that might be handed up and discussed. We say there is nothing at all new in the idea that there will be trial documents that you don't get to see at the time or afterwards. And actually, that's quite deliberate in the design of the arrangements for a very long time. But alongside this, one always has to put the role of the trial judge, which nowadays would be case management powers under CPR 3.1, and the overriding objective. And Lord Bingham's comments that you've seen in Smith-Klein Beecham, where judges are enjoined to take appropriate steps to ensure that a hearing is intelligible. And when one tests this analysis against the position of the reasonable observer, end of paragraph 110, understanding the evidence, arguments, or issues, we say that's a very good test and a very helpful question to ask. But don't forget the position that the reasonable observer is actually in, because the rules give express counterbalances right back to the recommendations of the Civil Procedure Rule of 1988. Now that we are going to have written evidence that stands as the evidence in chief, any reasonable observer at the trial, as of right, can inspect, not take away, inspect the evidence that stands as evidence in chief. You've got that at page 1748. It's CPR 3213. It's a very long pedigree, as we'll see.
Sorry, what was that page?
It's page 1748.
Thank you.
It's CPR 3213. The answer to this case, and then I will develop my 5 topics. The answer to this case. 1. A member of the press or public can seek access to the written submissions at a public hearing by asking the trial judge, and the trial judge can give them access. And that's very well established. It's Lord Justice Potter for the Court of Appeal in GIO And if you've still got the Court of Appeal judgment in our case, the relevant quotation, which is a very long one, is in the judgment of Lord Justice Hamblin at paragraph 68, and it's right in the middle. If you've got the law report, it's letter D on page 496. And if you haven't, it's in the quoted paragraph, which starts with the words, "this is particularly," right at the end of that paragraph, before the one that starts, "in exercising his discretion." And so that everyone can understand the substance of the point I'm making, what it is that in such a case, I have no doubt, says Lord Justice Potter, on application from a member of the press or public in the course of the trial, it is within the inherent jurisdiction of the court to require that there be made available to such applicant a copy of the written opening or skeleton argument submitted to the judge. And there's no reason to overlook the words "in the course of the trial." There's every reason why Lord Justice Potter would and should have included that. So that's point one. And that's skeleton arguments. And there is no constitutional duty on a former party, or for that matter, a lawyer, nor the court, to retain or make available skeleton arguments for some unspecified period of time. Point two, a member of the press or public can inspect witness evidence, non-expert or expert, that stands as evidence in chief during a trial. And that's the rule I just referred to, 3213, and it's, as I've said, page 1748. But if we're still with the Court of Appeal, you'll find it in paragraph 94, the rule having been set out in paragraph 93. Well, Justice Hamblin goes on to say, yes, but it doesn't stop there. In our submission, he is wrong. That's the right you've got. It's very carefully designed. There was a time, I think about 5 years, between 1992 and 1997, at which the certified witness statement would be taken to a room for 7 days where it could be inspected. And indeed, you could get a copy if you paid the relevant fee. And obviously, monitoring that, because you had to then keep a record of the use of that facility. And interestingly, it was the record of the use that was then kept on the records of the court, not the witness statement itself, which was returned to the solicitor or to the litigant. In the light of those arrangements, there was then an amendment, and the rule was made simpler. Inspection at the trial, and at the trial only. But even in the 1992 arrangements, as well...
Sorry, you say at the trial only. The rule, in fact, says during the course of the trial, unless the court otherwise directs. Wouldn't the ambit of the latter words mean that they could direct that it happens at a time other than during the...
Oh, in my submission, what that means is unless the court says that you can't. But I accept that one could read that, and if open justice required, it would read that as consistent with a court being able to direct further. But my submission is that clearly what that rule is doing is it's requiring you during the trial to say, I want to inspect this. And then a party can say, no, that mustn't be inspected. There's something personal in it. The person gives their address. That's not part of their evidence in chief. Or this isn't appropriate for inspection for other reasons. And even under the old certification arrangements, which we'll look at from 1992, it wasn't the case that all witness statements went to a room for 7 days. What was the case was that if somebody asked at the trial judge would certify or get the relevant court official to certify the version of the statement that stood as the evidence in chief, and then it would go to the room. So if you didn't raise it during the hearing, then the bird had flown. We say that's still the position. Point 3 then, a member of the press or public can obtain from the records of the court the documents either as a matter of entitlement under Rule 5.4c, that's paragraph 1, page 1642, or other documents filed which are in the records of the court with permission, and that's paragraph 2 of 5.4c, and that rule the court will find the Court of Appeal referring to in paragraph 39 of the judgment. In fact, 5.4c, it starts, the discussion starts at 37. On that, as you know, we say the Court of Appeal got that right for the reasons that they gave as to what the records of the court are. Now, the practicalities, respondent says they don't matter. We submit that would be very striking. The practicalities are firstly this, so far as the records of the court are concerned. There is an official and published document which relates to retention and then destruction or transfer for permanent record keeping to the local record office. That is volume 2, tab 20 in the paper, page 1946, 1946 in the bundle. And there they are, including for the family court, though we'll need to check what the arrangements are as to what goes in. But this is about what goes out. September 2017, volume 2, tab 20, record retention and disposition schedule. And you'll see it specifies then, second paragraph in the preamble, retention periods that apply to the records. And for the Queen's Bench and Chancery, it's 7 years. And then they're destroyed, or if they're particularly historically interesting, retained for 30 years and then sent to the local record office. And that's important because there are important statutory duties arising under the Public Records Act to deal with court records. So that's those are the arrangements. And as you know, Court of Appeal judgment, paragraph 42, trial bundles are not for keeping, they're for marking up and they're for removal. And it's just worth remembering that when you file the trial bundle under CPR Rule 39.5, which is at page 1792, you must file a trial bundle. And it contains the documents. And the window in which you file it, and file just means deliver to the court office under Rule 2.3, page 1603, you file that bundle in a 3 to 7 day window. Not more than 7 days, not less than 3 days before the start of the trial. So there it is, that's the bundle that is either waiting for the judge or going to the judge or being worked on by the judge or retained by the judge. We say those are the arrangements, and it is as straightforward as that. The records of the court give you a stable, durable, and clear set of arrangements where you can get things either before you've had a trial or after a case is finished. And it deals with the practicalities. It tells you that you can make an application under Part 23, because otherwise, where is the application you make when a case is over? And it deals with things like fees and the prescribed fees if you're going to get copies. And that is where you would expect a justice system to deal with the question of the obtaining of documents, court documents from a court after a case is over. Our submission, and then I'll dive a little deeper in relation to the various topics, is that there is no constitutional principle or right abrogated by the arrangements I have just described. And just leave aside for a moment public law and private law and whether we're talking about public authorities and leave aside for a moment whether all those statements about open justice is something that courts have jurisdiction to delineate. Of course they do. And let's assume that that converts into there must be a power to achieve whatever you decide open justice requires. Even if all of that is assumed against me, there is no basis for requiring anything beyond the arrangements I have just described, because there's no necessity for it. And if there's no necessity, or put another way, if the arrangements are justifiable and proportionate, there can be no abrogation. So no power, we say, exists to obtain trial bundles or trial documents or trial materials outside the rules. Still less after the case is over from former parties by dragging them into satellite litigation, in which you have to do investigations into what significance did this document have of the 5,000, and this one that the judge is to be taken as having read. Even if there were a basis for that proposition, it would need, we submit, to be grounded very clearly in the not possible for a reasonable observer to understand test at the end of paragraph 110 in the Court of Appeal's judgment. And on that point, it is relevant always to remember that our system of civil procedure rules gives as an entitlement anyone the ability to get the transcripts, not just of the evidence, of the entire hearing, providing they go through the route that is given to them for that purpose. Not by bypassing it, but actually going through it. Why is that relevant? Because it means anyone, and certainly an NGO who wants to take a case all the way to the Supreme Court, can actually get them and read them and look at them and explain why it is said that, having had access to that and put themselves in the position where they can now read what they would have heard, why it is the case that it is not possible to understand the trial evidence argument or issues without inspection of a document which the reasonable observer would have had access to, but they didn't bother because, notwithstanding, as their solicitor tells us at the very start of her very first witness statement, that this was a well-known, well-publicised piece of litigation, they played no part in it at all.
Can the reasonable observer have some other claim under consideration which he or she might wish to bring, and bring that into account in deciding, can that be brought into account in deciding what is necessary?
I would accept that when one is looking at the reasonable observer, you have to appreciate that there may be different reasons why you want to understand. But if you put yourself in the trial judge's seat, when you're dealing with any trial, it's not just about the parties, it's not just about appeal, it's not just about getting it right and giving them reasons that they will understand. I have to secure open justice. You ask yourself, am I presiding over a trial in which it's possible for a reasonable observer to understand the evidence, argument, and issues? And it's the trial judge's responsibility to do that. But I would accept in that sort of exercise, there might be different reasons why you do need.
Well, different levels of inquiry would ensue.
Yes, you'd have to make sure that you are not taking an unduly narrow approach to reasonable observer when you ask that question.
I mean, surely modern trials take place on a platform of an awful lot of material in writing read by the judge in advance of the trial. I mean, skeleton submissions and witness statements being the prime examples. And the oral submissions and the oral progress of the trial will reflect that, won't they?
They will, I accept that.
And so it may not always be possible to tell, just from reading the written transcript of what happened in court, the full ambit of what the court was taking into account in its management of the trial or in the course of the conduct of the proceedings.
That I accept. What I don't accept is that you couldn't use the transcripts to be able to demonstrate why it is that you face the impossibility being described at the end of paragraph 110?
Because you wouldn't know what was in the written materials which the judge will have read.
Yeah, but you'd be able to look at it. Just as someone, go back to my trial example on Lord Bingham's counterbalancing observations from Smith-Kline. Someone at court can ask for the skeleton argument. The judge decides whether they should get to inspect a copy, perhaps borrow a copy of the skeleton argument for the hearing. It'll always be the case that they don't know what they don't know, but the judge will be in a position to evaluate whether it is necessary or whether it's sufficient that counsel are identifying the key points, the key issues, and the key passages from documents are being read out as the Chancery Guide says they should be. And Lord Bingham also says that they should be. Now, can this court give guidance about possible new rules? Let's take the record. Is the record broad enough? Should other documents be placed on the record so they are there for a durable purpose under stable rules with the various arrangements? Should they be retained for more than 7 years, for example? And both the respondents, the forum, and the interested parties say that the court can give guidance, and of course we accept that. The court not only considers and delineates open justice and decides what it requires, but the court can perfectly well say, if it considers that there is a topic that needs to be looked at again, that the Rule Committee should be looking at. The Rules Committee, of course, have the statutory obligation to make rules under a statutory duty, section 1, subsection 3 of the 1997 Act. That's at page 1578. In the paper, it's volume 2, tab 18, still at 1578. Section 1, subsection 3, the 97 Act. They have to make rules with a view to ensuring that the civil justice system is accessible as well as fair and efficient. Those are the three things. Section 1, subsection 3. And of course, in making their rules, they consult. That's section 2, subsection 6 on page 1580. Not only that, if there is a constitutional principle here, then it is as much the watermark in the 1997 Act as it is the watermark in the civil procedure rules.
Might it be said that the section 1 presupposes that there is inherent jurisdiction in the court?
To make rules?
No, to govern the court procedure, and that the rules can be made to condition the exercise of that inherent jurisdiction? Or are you saying that the jurisdiction for court procedure is now given by section 1?
No, I would accept there is an inherent jurisdiction in a court to manage its processes. But what we submit, you'll see this very clearly when we go to New Zealand, but it's our submission in this jurisdiction, is that when you have rules that regulate particular subject matter, then it is to those that you look. And if one is going to invoke open justice to say that some other power is needed, then what will be required is a necessity test. But I accept, my Lord, one puts it that way round. And so, for example, if there were no provisions relating to the records of the court, there would be an inherent jurisdiction in the court to deal with the records of the court. Now, any reform, we say, it's our paragraphs 14 and 70. We do it by reference to Professor Dockray's article and Sir Ernest Ryder's recent speech. Any reform, we say, requires consultative design. If you are going to look for arrangements that expand the court file or change the way in which court documents are dealt with, then yes, under the guidance of a Supreme Court, of course. But one does need to consider and consult and have a wide range of views and look at logistics and look at how it relates to digitalisation and when's the right time? And is it going to be prospective or retrospective? And how are you going to deal with fees? And how are you going to deal with practicalities? And where are you going to put the 17 lever arch files? What does it mean for them to be accessible? How are they going to be stored? And all those sorts of questions. And is there really a need? What's the actual evidential basis for there being a need? And is it appropriate to drag former parties into satellite applications of the sort that is envisaged in this case? So the insolvency rule that we mentioned, that my Lady Hell had alighted on and we discussed just a moment ago, that's page 3476. It's Rule 1239 in the insolvency rules made under the Insolvency Act. And in the paper copies, the Act is at 777, so that you've got the source power for these rules. And the rules themselves are at 7 tab 82.
Well, I think we're all using the electronic bundle, so we don't have them in hard copy.
3476 then, you can go straight to it. And as I pointed out earlier, you can have a rule, the court file, where documents are filed with the court under the Act or these rules. And in insolvency, there's quite an elaborate mechanism, as you all know. We've given you some of it in this same tab. The court must open and maintain a court file and place those documents on the file, and then sub-rule 3 on that page, 3476, then tells you who may inspect it and sets out various rules. Is the open justice principle abrogated by the absence of a rule of that kind in the civil procedure rules? We say no. Is the open justice principle abrogated by the provision that says bundles for the witnesses at a trial must be brought by the parties, but it doesn't require them to be filed or retained? It's Practice Direction 39A, paragraph 310, that deals with the bundle for the witnesses. Or in the same practice direction, paragraph 7 deals with exhibits. Exhibits go into the custody of the court during the trial and are then returned to the parties to be removed, and the parties are to retain them during any appeal period. That, again, is paragraph 39, practice direction 39, paragraph 310. The page numbers for both of those you will find at 1797, bottom of the page, supplying the bundle for the witnesses, and then 1799, middle of the page, is the exhibits. The exhibits are kept in the custody of the court until the conclusion of the trial, unless the judge otherwise directs. At the conclusion, the party's responsibility to take them away. Is there an abrogation? What if a member of the media wants to look at an exhibit that was used at a trial? Or as Mr. Bunting would say in his submissions, in his intervention, they must be allowed to do that. They must be allowed to do that years after the event. Or in the arrangements, where there are not a spare 17 lever arch files that are then stored, or for that matter in the arrangements that say after 7 years destroy the court records. Is that an abrogation of the open justice principle? And if these things are abrogations, they've been going on a very long time, and a large number of people who understand perfectly well open justice have misunderstood.
But you seem to be saying that it is an abrogation of the open justice principle because the courts ought not to go beyond these rules.
I'm sorry, I don't understand that question.
Well, you posed to us the rhetorical question, is practice direction such as paragraph 7 an abrogation of the open justice principle? If it isn't an abrogation of the open justice principle, that suggests that the open justice principle, in theory, goes wider than this. The court can, if it thinks right, make orders going beyond paragraph 7.
What I'm submitting is that the open justice principle is faithfully achieved by the arrangements that I've outlined.
But you would accept that if it's not?
I'm
The
going to
court
have
can
some
go
submissions
wider.
to make about how many hurdles one has to get through to get to that position. But yes, I don't deny, I'd be the last to deny in this court that there's a room for constitutional principle for the courts to recognise, but one does need to handle it with extreme caution. Records of the court. We say the Court of Appeal got this right. It's between paragraphs 36 and 55. We deal with it between paragraphs 31 and 40, and then in our conclusion at 71 and 72. It comes to this, my ladies and my lords. The forum says, and it's their primary case, that the correct interpretation of Rule 5.4c2, page 1642, is that subparagraph 2, a non-party may, if the court gives permission, obtain from the records of the court a copy of any other document filed by a party or communication between the court and a party or another person. They say the proper interpretation of that is it means filed with the court and currently retained by the court. That's how the master had approached it, as the Court of Appeal judgment explains at paragraph 47 in the middle of that paragraph. The master's approach, paragraph 47, right in the middle, appears to have been that any documents filed with the court become records of the court and remain so for as long as the court holds them. So in this case, the judges marked trial bundles, which have not yet been collected. In response, the rule does not say obtain from the court, which is what it would. If it was as simple as the court's got it and it's been filed and you can have it with permission, you would not design the rule to say obtain from the records of the court. You would say obtain from the court. Records of the court connotes the formal documents. It all starts with the idea of a court of record, but it leads you to a court file based on a practice. And the flavour of it is seen by the list of examples that you get in the practice direction. And the practice direction is all set out by Lord Justice Hamblin at paragraph 31. So, for example, the list at paragraph 31 includes an application at H with the written evidence filed in relation to an application at I, paragraph 31. So what you get in the court file, in the High Court, is that you get claim documents, statements of case, and you get application documents and other documents that are filed with them, and miscellaneous other documents that are retained in the court file. The natural meaning of records is that it's something to be retained. That's what a record is. Somebody sends you something for your records. It's being kept in the court office, and of course it's the court office you go to inspect it, not the judge's room or wherever else in the building some exhibit is being held. And as the Court of Appeal explained at paragraph 39, that's all supported by the clear commentary in the White Book, kept in the court office as part of the file. Now, the court has in this case direct evidence. And if you turn to page 702 on your screens, it starts at 701. It's a witness statement of my instructing solicitor, Mr. Jones, who told the Court of Appeal at 702 that they'd inspected the court file. Paragraph 5 on 702, this is what it is. It's red foolscap card documents, wallets. each holding approximately 300 pages of A4, and they'd got as far as having two for this litigation. And then, having been allowed to inspect it, at paragraph 7, they then make a list. And the list starts at 7:05. So we actually know what is kept on the court file in this particular case. It's directly linked to the retention schedule that we've already seen, the 7-year arrangements. And it's linked to the retention schedule because of the Public Records Act duty, to which I've already alluded. And if you want to see that, my ladies, my lords, it's 3316, page 3316, in the Public Records Act of 1958. And one needs section 3 first at 3316. 3.1, it's the duty of every person responsible for public records of any description which are not in the Public Record Office to make arrangements for the selection of those records which ought to be permanently preserved and for their safekeeping. Well, you've just seen that. The permanent preservation is beyond the 7 years, by reference to the criterion there stated. Does that include court records? Absolutely. See page 3320, section 8. The responsibility for the court records is on the Lord Chancellor. Of course, the whole point is that they're made secure, you can inspect them, and you have proper arrangements to deal with them. Section 32 of the Freedom of Information Act is relied on against me, but that doesn't help. Section 32 can be found in the bundles at page 3421. 3421. It doesn't help the forum because it's dealing with exempt information under a heading court records, etc. 3421. And it then refers to information held by a public authority which is exempt if it's held only by virtue of being contained in any document filed with or otherwise placed in the custody of a court for the purposes of proceedings in a particular cause or matter. So a good example would be an exhibit at a trial. But that's not saying that that's the records of the court. It's court records, etc. So to the extent that that covers us, it rather makes our point. As the Court of Appeal said in the GIO case, and this is paragraph 45 in the Court of Appeal's judgment in our case, trial bundles are not held by the court as a public record. That was his phrase. Interestingly, under the rules of the Supreme Court, that was not the phrase used as the rules entered their sunset days, and we went into the civil procedures. But by then, the civil procedure rules did use that phrase, so it reinforced his point. The rule makers deliberately said, you may obtain from the records of the court. So GIO, the Court of Appeal, explains that this does not cover trial bundles, and also records that the then Mr. Leveson had recognised that in his submissions to the Court of Appeal. Moreover, all of this must have been deliberate. If one goes back to what I was telling you about the 1992 arrangements, I explained that in 1992, arrangements were made for the inspectable witness statement to be retained within the court building to be accessed. And if you go straight to 3616, starts at 3615, this is the practice direction that accompanied that rule. So the rule has been made by Lord Chief Justice Taylor and others at page 3611, the team being set out at 3613, that's the rule. Then the practice direction at 3615. If you get a certification, paragraph 2 on 3615, then you get a certificate generated. At the conclusion of the trial, I'm reading paragraph 4 in the third line, the documents are removed to a room appointed by the chief associate. They're not put in the records of the court. They're taken to a appointed room. Then you can get a copy of the certificate and a copy of the certified copy if you have the right application form and you pay the right fee. That's the top of 3616. And then at the end of the 7 days, the certificate form and the application form shall be filed and recorded in the Associates Department of the Queen's Bench Division. At the same time, the Chief Associate shall return the certified copy to the solicitor or litigant in person. So they've actually thought about it. And it would have been the easiest thing in the world to say this will go into the records of the court so that there can be access forever, or at least for as long as the records of the court are retained. Very clear that that's not the arrangement. My learned friend is going to seek to persuade you that for centuries every document has been available in court records. We don't accept that for a moment. Indeed, one only has to go back to the White Book of 1967 at page 3530. By the time of the White Book, 1967, the commentary on that page is explaining in the second paragraph of the commentary what you can get if you're a party and what you can get as of right if you're a member of the public, and then what you need permission for, so you don't get as of right if you're a member of the public. And on that last category, it says this. It's 3 words in from the left-hand side. The effect of the restriction, that's to say you need permission, is to exclude the right of the public to search for and inspect the following documents, viz. Affidavits, depositions taken before an examiner, judgments and orders given and made in chambers. The principle on which these documents are excluded from the public right of inspection would appear to be that they are all interlocutory in character and may or may not come to be used in open court. So it's understood that you can search from the beginning to see what claims people are making, what applications people are making, and you can search to see what courts do, what orders do they make, and so on and so forth. But nobody thinks that you can search in the records for trial documents. And the rule itself's on the previous page, 3529, and just to complete the picture by using that White Book reference, if you go back to the beginning, 3527, you'll see at the bottom of 3527 there's a description of the filing department. They deal with filing of affidavits and depositions and so on. And if you look at the top of the next page, it's that department that deals with storage. 3rd line at the top of 3528. And if you go near the bottom of that page, 3528, about 8 lines up, you'll see a little note that says filing department. This has been formed by amalgamation of the filing and record, bills of sale and enrolment departments. So all of that, we say, strong reinforcement for the conclusion the Court of Appeal reached. There is no High Court judgment which concludes that records of the court means anything the court currently holds, but to the extent that it is said that there are any observations that support that conclusion, they are wrong. The Court of Appeal dealt with High Court judgments at paragraph 47, making the point that either it's not an issue or not argued, even if it was being assumed. I'm not going to repeat the other points we make. in our written case, or the other points that are made by the Court of Appeal on this point. We submit, court below was right, forum can't get the judge's trial bundles through the records of the court provision. Can I?
Can I just check, records of the court, does that first come in with the first edition of the CPR?
Yes.
Okay, thanks.
Just before we leave all the technicalities, going back to the entitlement of a party to inspect a witness statement during a trial.
Yes. Of anyone.
Yeah. What was the practical method by which the exercise of that right was conferred? What would they get to inspect? Would the court office keep a separate clean set for that purpose?
Yes, what
would it be
happened?
the judge's copy, or would one of the parties be directed to produce their copy?
If we go back, yes, if you go to 3611, 3611, paragraph 14 of the new Rule 2A, Order 38, where the associate is directed in the paragraph 12 to certify a witness statement that's open to inspection, he shall prepare a certificate which shall be attached to a copy of that witness statement and make the certified copy available for inspection. So you create a copy, and one of the things that, one of the reasons why the judge was certifying is in order to address, a bit like you would in the Crown Court with a statement that's read out, to actually make sure that you've got the bits that are standing as oral evidence. So that would be the mechanism. The trial judge at 12, if any person so requests during the course of the trial, and it's a duty on the judge, direct the associate to certify as open to inspection a statement ordered to stand as evidence in chief, and then the copy has to be then created and certified, and it's the making of the copy that is dealt with by 14B, I hope.
And sorry, which rule are we looking at here? You did tell us, I didn't.
It starts, my lord, at the bottom of 3609. It is the new Order 38, Rule 2A.
Which appeared, what, in the last edition of the Royal Rules of the Supreme Court?
It appeared in 1992. You'll see that on 3608. And we might as well do this while we've got it.
That was the regime under the RSC.
Yes.
What's the current regime?
What then happens in 1999 is that the inspection right, 7 days afterwards, and the copying and the payment of the fee all goes. And so what happens is that it's simply the right to inspect during the course.
Yes, I'm sorry, I think you may have misunderstood my question. My question was simply how the practicalities work during the trial, not during that temporary period when there was a 7-day period for inspection thereafter.
Is there a provision that says who makes the copy?
I mean, the regime we're now in doesn't have that 7-day period for inspection.
No.
It was, one assumes, consciously not continued.
In 1999.
Yeah. So what are the practicalities now?
What's the reference to the current rule dealing with witness
current,
statements? The page reference.
Yes. The current rule, I'm told, is 1748. It's bottom of 1748. And the rule simply says that a witness statement that stands in evidence is open to inspection.
And you've taken us to that, but I'm simply inquiring, how does that work in terms of practicality during a trial? Because the picture which you create, probably correctly in your case, is that what there will be at the trial is the judge's copy of the trial bundle, which will include witness statements, and the parties' copies, but not necessarily a separate one held by the court. Yes. So how, on the assumption that the judge may have marked and made comments on a witness statement, does this work in practice?
Yes, I'll see if we can do any better in relation to the arrangements. I mean, we know that you have to bring a clean copy of all of the bundles under the rules, but that's specifically so that the witnesses can deal with it. The practicalities are either going to be, and I'll see if I can improve on this, that the court makes a copy that can then be seen, or that the parties make another copy that can then be seen. The inherent jurisdiction, and what do I accept, and how do you get to it? First, some points about the inherent jurisdiction. In principle, we submit that the inherent jurisdiction remains operative where there is firstly a gap in the rules, and secondly, a necessity for a power and its exercise. And we deal with all of that in paragraphs 11 of our written case. And you'll find our paragraph 11, my ladies and my lords, at page 117, where we cite, by reference to authority at the highest level in relation to all three propositions, and I hope these are hyperlinked, they should be, at page 117, paragraph 11. Procedural and substantive arises only insofar as necessary to enable the court to discharge prescribed functions properly. Lord Nichols in Nycredit. Only to be invoked where there is a gap in the procedural rules and not inconsistently with a valid rule of procedure.
And what is meant by procedural and not substantive in character? Because, I mean, plainly it seems that some substantive effects can be achieved.
My lord, that I would accept.
So can you help us what is meant here by procedural and not substantive?
Perhaps I can help in this way, my lord. I would accept that if I am wrong about everything else, then it would be a procedural matter for the inherent jurisdiction to deal with this issue. So let me reflect and see if I can, at the end of my submissions after lunch, do better than that.
Thank you.
But necessity, absolutely, and gap in the rules, yes, we say. So that's the first thing. You're looking for a gap and for it to be necessary. That's before we've even got to the open justice principle. Secondly, because we're looking at a case where the trial judge is functus, because you've seen the order that was made, final ruling, the proceedings are dismissed, that means that we are in Taylor and Lawrence territory, and you'll find Taylor and Lawrence, the key passage, at page 2547. 2547. Paragraph 6, Taylor and Lawrence, Court of Appeal discussing its limited jurisdiction to deal with matters arising after a case is over. And it's the bottom of page 2546 in the citation from Lord Wilberforce in the Ampthill peerage cited by the five-judge Court of Appeal in Taylor and Lawrence. For a policy of closure to be compatible with justice, it must be attended with safeguards. So the law allows appeals. The law exceptionally allows appeals out of time. The law still more exceptionally allows judgments to be attacked on the ground of fraud. Limitation periods may exceptionally be extended. These are exceptions to a general rule of high public importance, top of 2547. And as all the cases show, they are reserved for rare and limited cases where the facts justifying them can be strictly proved. So if a court is to have and exercise a jurisdiction which is not given to it under the rules, we say there is already a high degree of necessity and the need for a gap by reference to this principle. If you turn on at 2557 or click on to page 2557, it's there that you get the needs must principle that will be familiar to the court, but it's at 2557 from the speech of Lord Diplock in the Bremer-Vulcan case, and at the very end of that passage, talking about the doing by the court of acts which it needs must have power to do in order to maintain its character as a court of justice. And then the Court of Appeal, in our judgment, the final words of Lord Diplock, the ones I've just read, express the situation here under consideration exactly. So that's to say, court having jurisdiction in a case after the case has been finally determined, which is our case.
Well, yes, it is, but these cases were about actually reopening the decision that had been taken.
My submission is that if you are going to exercise a jurisdiction over the parties and make mandatory orders that require them to take steps, I would include in that reopening questions of costs, for example. The court needs to be satisfied that there is a needs-must basis to maintain the character of a court of justice. You can see where I'm going, but I'm laying the
I can see
steps.
where you're going. I'm
Yeah.
just pointing out
Yeah, no, I accept that's the context, but you're dealing with a court who's finally disposed of the matter. And I repeat...
But I mean, you made the point that it's functus officio, and I can see that it is in relation to final disposal of the matter. But if there is an inherent jurisdiction in the court to protect the integrity and transparency of the court process, is it really right to say that it's become functus officio in relation to that?
Well, in my submission, that's really to beg the question, because the question is there an inherent jurisdiction to take further steps? You then say, well, what's the court's position under the rules? Two things. Firstly, it's done its job under the rules. Secondly, subject to specific rules that endure and deal with access to documents, 5.4c. You can apply at any time under 5.4c. And to ask the question whether there is an inherent jurisdiction, you apply this test. That's the way we put it. Moreover, we submit, it's our paragraph 14, special caution is called for in novel situations, particularly if what is involved is a major change, calling for rules and design and consultation. And that's all Professor Dockeray. It's pages 5154 and 5155 in the bundles. So that's the inherent jurisdiction. What about the open justice?
What's the background to Professor Dockeray's article? What's it all about?
He's writing about the inherent jurisdiction, and he's been cited with approval by Lord Dyson, as we say at paragraph 14. It's a brilliant article, and if you wouldn't mind it, just looking at the final passages of it, then at 5152. At 5152, Professor Dockeray discusses the various ways that the inherent jurisdiction is sometimes put. At 5152, about 8 lines up, he makes the point that the inherent jurisdiction may supplement but cannot be used to lay down procedure contrary to or inconsistent with a valid rule of the Supreme Court.
So, sorry, where are...
5152, my lord, about 8 lines up. And
It's the final sentence in the last main paragraph
yes,
on
it
the
is.
page. Yes.
I see, yes, thank
Yep.
you very much.
Then he discusses whether there's an inherent jurisdiction to do anything the court thinks necessary to do justice in pending proceedings. Interesting a reference to pending proceedings and says that that's been rejected. Gives the authorities at the top of 5153. Then he discusses about 6 lines down the inherent power to do whatever is necessary to make orders effective, which has now got a statutory underpinning. And then we get the needs must passage that we just saw in the middle of his 5153. But what he says at the bottom of 5154 and over the page is what I was referencing. The factors that are influential in novel cases, asking what contribution the proposed power could make to the effective administration of justice in the substantive and procedural context in which the rule would be applied, reasonable necessity as a popular standard, the impact which the proposed power would have on persons subject to it, the importance of the rights affected, the extent, top of the next page, 5155, to which those rights could be protected by provisions of an express order of the court, the degree of confidence with which the court can determine where the balance of fairness lies, the implications to be drawn from limitations in existing statutes or rules in the field, the scale and complexity of the proposed regulation, the practical difficulty experienced by the court in applying it, and the degree to which the proposed power represents a deviation from established practice. More generally, says Professor Dockery, a preference for major innovations to be introduced by legislation is clear in many, but by no means all, of the decisions. He says that cautious approach has a lot to be said for it, and it's a point he picks up on in his conclusion at the bottom of the next page, 5156.
He also says inherent powers are wide and important.
Yes, it does.
Is that right? Yep.
Even the best procedural codes cannot be expected to foresee everything, etc., etc.
That, of course, I accept. So that's inherent jurisdiction. The open justice principle, if we step back from it, the heart of the open justice principle are the dual values of the hearing being in public and being reportable. And that we explain in our printed case by reference to the relevant authorities at paragraphs 41 and 46. The key, as we've seen from the Court of Appeal judgment, to open justice and information from the court is intelligibility, the reasonable observer being able to understand the issues and the arguments and the evidence at the trial. And we say that the key point at which open justice is most directly relevant is at the time when the court is dealing with the matter. Now, all of that is set out and explained by reference to authority in paragraphs 41 to 49 of our written case. And so it follows that we are not at or even near the core of the open justice principle when we are concerned not with whether the hearing is in public, not with whether what is said in open court can be freely reported, and not with whether you can understand what's being said, and not with someone who is seeking to understand it while it's happening. Indeed, the intervener in their written submissions, having helpfully set out key purposes that the media meets in the context of open justice, page 203, paragraph 8, then rightly concedes at paragraph 9 on page 203 that those purposes are reflected in the provisions of the CPR. And it's therefore wider purposes that they have to seek to invoke in order to say that there is some problem. And that leads them into a whole narrative. See paragraphs 11 and 12 and 13 on page 204 about miscarriages of justice that have happened in the past, and investigating historic cases, and even looking to see what evidence wasn't adduced in the case. But one does need to be careful in our submission. For how many years is it said that this open justice duty endures? Or put another way, for how long into the future can a party be brought back before a court to face a mandatory order to provide material relating to a hearing? We say the key point is that the aims and purposes that are at the heart of open justice are reflected within the rules and arrangements. Now, why does it matter to focus on the position at the time of the hearing? May I suggest these reasons? Firstly, if we go to the before the hearing position, everybody accepts in this case that open justice is not engaged by these trial bundles the day before the trial starts. If the case had settled the day before, all the documents would have been the same, they would have been in the same place with the same content. But the forum accepts that they could not invoke the open justice principle to obtain those materials. They still have an argument on records of the court. So that's very revealing. We are in a world where the temporality matters. It also matters if you're on the potential receiving end. Because if you want the protection of a witness statement not being inspectable, or if you want the protection of a document in the records of the court not being inspectable as of right, you have to act proactively. There is a provision in 5.4c where you can get an order. It's 5.4c sub rule 4. You get an order that prevents the file from being inspected, and you then get notified if there's any application. So timing matters. And the timing matters if you're wanting to secure a protection. The timing also matters in principle for this reason. It's at the time of the hearing that the court has its responsibility to secure the open justice principle and has its powers of case management control. 3.1 of the CPR. It's at that time that the parties are necessarily before the court, and they are necessarily incurring litigation costs. It's at that time when the court is regulating its own proceedings, because there are proceedings, and the judge is dealing with proceedings. And it's by focusing on that time that an informed judge can deal properly with requests that are made, and on an informed basis, without the need to have some, after the event, inquiry of reconstruction. Now, if one puts oneself in the position of the trial judge, it's a very good way of testing this case, whichever way you come out. You're the trial judge, 6-week hearing. It's our paragraph 57. And the forum comes along and they say, we know about this case, it's an interesting case, it's an important case, and we would really like to make sure that we understand. First of all, the skeleton argument. Well, you go to GIO and you would ask that question of intelligibility and understanding to exercise that inherent jurisdiction which we accept, because there's a gap in the rules. so far as the skeleton is concerned. And if you were persuaded at that time, you would let them see it. You wouldn't let them take it away in our submission. But if you really need it to be able to understand, you may very well, though, say, actually, you don't need the skeleton argument. I'm conducting this trial and ensuring that the substance can be understood by
Do you
reason.
know, I'm looking round the room and I'm asking myself, do I know how many of the people in this room can follow your argument properly just by listening to you? I don't know the answer to that because I've got all the other materials and I'm looking stuff up on my machine. It's not an easy judgment to make.
No, it's not. And the first thing you would do,
I'd ask them.
yeah, if somebody didn't and wanted to have a document in order to understand, they're perfectly entitled, whether they're media or otherwise, to ask for it, and you would consider it, and so would we. And if you're interested in a structural sense, as a Supreme Court who is so open that you've got the cameras running, and so open that you do a nice little synopsis, so I don't need to introduce the case because everyone's got a piece of paper which accurately says what the issues are and what it is all about. Where does it go? Well, the first place it goes is to your user group, probably, but in any event, to some discussion on the basis of inquiry and information to decide whether you're going to do what the Hong Kong Supreme Court does, or Court of Final Appeals does, I believe, in Hong Kong. Are you going to put things on the internet that the parties provide? Are you going to do it the day before so that people can have it in front of them and look at it? But it is our job, all of us, because if there's a constitutional principle of open justice and the overriding objective is read against it and the parties have to secure the overriding objective, we have to do it as well, which is to think not just about how do I get into the mind of the judge that I am trying to persuade, but what am I doing in the public arena? But if there is a problem, that's the time to address it. And that's what GIO says, and everyone can read it in the law reports. If you want the skeleton argument, apply for it during the trial. You may or may not need it for those purposes. And of course, exactly the same for the witness statements, because the rule has been expressly designed after the Civil Justice Review recommended it in 1988. Inspection of the witness statements. After the case is over and the court has finally disposed of the matter, are you going to have applications back to the court to bring us all back? Say, we'd like the documents, please, that were in the appendix. Forum turns up. It's necessary now because of an interest that we've got in it. We didn't raise it at the time. Or are you going to have stable, clear, and practical rules that govern access to court documents?
But suppose, even on your argument, it's taken a third party a while to get the transcript, to scrutinise the transcript, to realise after reading the transcript that there are gaps in the information which mean that they, as a reasonable third party, need more information to understand what was going on. Are you saying, well, that's tough, it's all just too late?
Yes, I am.
Right.
I'm saying that the heart of this, the hotspot for principled and practical reasons, is the hearing. And if there is something wrong with that, then what is needed is an amended version of arrangements that deal with documents that are retained.
But why wouldn't that count as a gap in your scheme?
If it satisfies the test of constitutional necessity, then the open justice principle will require it.
Right, but so that rather suggests that if one frames the question as I sought to frame it, that it was necessary for an observer to have access to this information, even though it takes a while for them to digest everything else that's been going on, to appreciate that one would say that the court had jurisdiction to
I don't accept that. I don't accept that. But if the court concludes that it meets a test of strict necessity, that a person be provided with material from the court and if you conclude that the arrangements I have described are therefore an unjustified restriction on a right of open justice, then in those circumstances, I accept that you would be identifying, in fact, not even a power, a duty. Even that, I submit, does not extend to making orders against former parties or third parties. It doesn't follow that anything goes, even if you decide that some outcome is necessary. And that takes me to my next point, and this is the point about the jurisdiction to delineate, as I've called it, the the open justice principle. The court will find this set out in our paragraph 65, and you'll find our paragraph 65 on page 156 at the bottom of the page. And this is the idea of the court having an inherent jurisdiction to determine the ambit and application of the open justice principle. We'll see it when we look at Guardian, as we will shortly at paragraph 69, but it's also picked up by Lord Reed in the A and BBC case at paragraph 27. Now, I accept, and indeed you're doing it right now, that this court has the jurisdiction to decide what open justice requires. What I don't accept is that it follows that the court must have any power to secure the position that the court decides is required by open justice. And let me test it. Suppose you were dealing with access to justice, another constitutional principle. And suppose you were dealing with a case where you were quite satisfied that someone's access to justice required them to have funding. But there's no legal aid because of LASPO. Does the court then make a preemptive costs order against a private party, take the McLibel type case? I'm going to make an order that you must pay the costs prospectively of somebody else so that they effectively have got state funding, because the court has ordered it, to secure their access for justice. Or take an example where the press says, well, we're interested in an expert who appeared in a case a few years ago, and what we're investigating is whether the CV they put before the court was misleading. The court hasn't got it. We can't get it from anywhere else. Will you order the former witness to the proceedings to supply a copy of that document to us, the press, because it's necessary as a matter of open justice? Or take this example, which we give in our printed case and nobody's gone anywhere near. Letter handed to a sentencing judge and read, not uploaded to the digital file. can you, years after the event, as a Crown Court, make an order against the widow of the former defendant who's now got that letter because the media are now showing an interest in it? Our submission is it doesn't follow from the court is satisfied that that material should be available as necessary in the under the open justice principle, that any order can be made under the inherent jurisdiction.
But I thought you were accepting that there is the inherent jurisdiction if there is necessity, unless that jurisdiction has been abrogated by some express rule.
From the court, I said. I don't accept that there is a jurisdiction to make a mandatory order against a third party.
I see. So it's the mandatory order against the third party that you're now on. Is that right? Sorry, I'm just a little bit unsure where you are.
Yes, where I was is that just because you have jurisdiction to delineate what open justice requires, it doesn't follow that a court has the power to make any order that it regards
Right.
as appropriate to secure that outcome. That was the point I was on, my lord.
Yes, I see. Thank you.
Guardian, then, we have, and you'll know it, and it's set out in some detail by the Court of Appeal. You've seen in our printed case what we say about Guardian. It's paragraph 61 to 64 of our case. And we make the point, and this is not contested, that Guardian was a case of extant proceedings for the Crown Court. It was an application made to the trial judge, and there was then a judicial review. It was documents held by the criminal court, as the intervener concedes at paragraph 19. And it was a situation where there were no rules that were applicable at the time. Rules had subsequently come in. It's in that context that Guardian expresses the default position that the then Lord Justice Toulson explains at paragraph 85. And you'll find that at page 1355 in the bundle. In a case where documents have been placed before a judge, 1355, paragraph 85, and referred to in the course of proceedings, in my judgment, the default position should be that access should be permitted on the open justice principle, and then where access is sought for a proper journalistic purpose, the case for allowing it will be particularly strong. And then at G, the court has to carry out a proportionality exercise, fact-specific. Central to that evaluation will be the purpose of the open justice principle. And if you go back on the previous page to 1354, it's at paragraph 79, that you find at the end of 79 the description of the purpose to enable the public to understand and scrutinise the justice system of which the courts are the administrators. Now, the first point to note is that that default position is the approach that informs the discretion under 5.4c. And that's the point we're making. We cite a case called ABC. There are a number of cases, and I've already shown you it in the Court of Appeal's judgment, when they cite authority in relation to the application of the rule. So if you've got records of the court and you're seeking permission, the default position is that if it's been relied on in open court and read by a judge, that you will get that permission. And that, we say, is the reconciliation between that Guardian default position and the framework of civil procedure rules. If one, again, just steps back from it and asks, is there an abrogation of a constitutional value in terms of paragraph 79, the purpose of enabling the public to understand and scrutinise the justice system for which the courts are administrators? In the arrangements I have described, we submit that there is none. There's no unjustified interference in requiring people to make their applications during the trial, bearing in mind that they are told that in the clearest terms in the relevant authorities and specifically on witness statements in the relevant rules. There's no abrogation in it being an inspection and not a right to take away a copy. And there's no abrogation in the rules setting out that, yes, you can access the court file before you even had a trial, and you can continue to access the court file after there has been a trial for up to 7 years. Now, we've submitted in our printed case that the guardian principle needs to be recognised as one of those constitutional values that operates through the principle of legality. And although that's disputed, at least by the intervener against us, we submit it's really very clear that that is the approach that's being taken. We're in the realms of a constitutional principle. See paragraph 69, 1352. It's for the court to determine its requirements subject to any statutory provision. And then you get the paragraph I promised you would see, or the passage I promised you would see. That's the delineation point.
Sorry, are you now back in the Guardian?
I'm in Guardian at
Yes,
1352, my lord.
Thank you.
I'm at paragraph 69.
Yeah.
Open justice principle is a constitutional principle for the courts to determine subject to any statutory provision. Courts have an inherent jurisdiction to determine how the principle should be applied. I've called that delineation. Then at 73, reference to parliamentary sovereignty. And this, in the third line of 73, Parliament should not be taken to have legislated so as to limit or control the way in which the court decides such a question. That's to say the limits of the open justice principle, unless the language of the statute makes it plain beyond possible doubt that this was Parliament's intention. And so if one just pauses to reflect on common law fundamental rights, such as in cases like Sims, constitutional values or tenets of the common law like legal professional privilege in Morgan Grenfell, access to justice in a case like Unison, the rules on court fees to go to the employment tribunal, and now the open justice principle. We submit all of those are matters that are to be located within this principle of legality, so that the court will look to see whether a constitutional right or value is being overridden, to use Lord Hoffman's phrase, or abrogated, to use the words of Lord Hophouse in Morgan Grenfell. And in fact, the intervener has included in the bundle a case which makes this point very helpfully. It's at page 6349. 6349. It's a case called DSD. It's about the parole board, and there was a rule that said you didn't get any information from the parole board, and you'll see that rule if we just go back to 6327 at paragraph 76 in the judgment of the Divisional Court, where the rulemaker at page 6327, letter F, had made a prohibitory rule. Information about proceedings under the Parole Board's procedure rules must not be made public. That was then the context for a discussion of fundamental rights that starts at page 6349. And two fundamental rights are identified. The first is, at paragraph 170, the open justice principle, and at the end of that paragraph, guardian, the obligation to ensure that evidence or information communicated to a court is presumptively available to the public. See guardian.
I'm so sorry to interrupt, but I mean, this is looking at reading down rules which prohibit you from doing something, and one understands the principle of legality, it's a principle of statutory interpretation. I didn't understand you to be saying any rule fell to be read down. So how does this fit in your argument?
How it fits is that I've given you a framework of rules on which I rely, like the rule that says if you want the witness statement, you have to ask at the trial and you'll get to inspect it. It's very clear.
Right, but, all right, yes. Sorry.
Right. The question then becomes, does that set of rules fall short of what the constitutional open justice principle requires?
Right.
Because if it does, but only if it does, is there a basis for finding an inherent jurisdiction?
Right.
And my submission is that when one examines rules against a constitutional principle of that kind, you're applying a necessity and proportionality test. And you're doing it through the principle of legality. So I start with, we've got our rules, and this is what they say. And that's where it ends. I'm then told, no, that's not good enough, because open justice requires something else. And if that's right, it's because there is a need for something which the rules do not provide. Same with we can look at unison. Unison wasn't, you can't go to the employment tribunal. It was, these are the fees that you have to pay, and these are the arrangements about waiving them to go to the employment tribunal. And what you find in unison, and in this case DSD, is the court examines against a standard of necessity and proportionality the arrangements that are being relied on. And that, in my submission, is what you will be doing.
Yes, thank you. I'm so sorry, I stopped you. You're going to take us to another reference with it.
Yes, so top of 6352, you'll find the second fundamental right that was in play, 180, fundamental right of access to the court. So you've got the two constitutional principles. You know what the provisions are. You get the principle of legality at 189, Lord Hoffman, fundamental rights cannot be overridden by general or ambiguous words. And it leads the court, the divisional court in the D case, at 6354 to the question of justification, 191. The primary legislation contains general and ambiguous words which do not expressly authorise any trammelling on of fundamental rights.
This reasoning is very, very like the reasoning in the unison case.
Yes.
You've got a generally expressed statutory power to make rules, which has been operated in a way which is contrary to a fundamental principle, right, including the principle of open justice, and the rules are held to be ultra vires.
Right.
It's the same reasoning process. I'm having a little bit of difficulty in working out how it fits in.
Let's just end the citation by seeing if we can at 6355, paragraph 198. The question is whether the rule goes too far because it imposes a prohibition which is not the minimum necessary to protect such rights. Is it unnecessary and disproportionate? So the submission is this. This is the parallel. Suppose you have rules that regulate access to the employment tribunal that lay down fees. And the argument is there has to be a power to allow someone to come to the employment tribunal who can't afford to pay that fee. You start with your framework of rules, you say they're very clear. Don't pay, can't go. Court says, well, there's a constitutional principle here that justifies finding a power. the test you apply is, does this framework of rules abrogate or interfere in a way that is unjustified and unnecessary with the constitutional principle? And it would be very odd if an inherent power driven by a constitutional imperative did not have to meet a test of necessity, particularly in the context of such carefully designed procedural rules.
But it might be said that it's enough that it balances the rights between the parties affected by the order sought, rather than a test of necessity.
Yes, well, in my submission, the power has to track what is necessary to give effect to the constitutional principle. And in getting to the conclusion, you have to balance interests in order to decide the outcome.
But many things, many approaches may be compatible with the constitutional principle. I think that's what I'm struggling with on this part of your,
All right, well,
your submission. I can understand if you have a rule saying something may not happen, and in substance that is, in practice, what was going on in the Unison case. Because fees had to be paid, some people just couldn't come to court. And then the question is, are those prohibitory rules so out of kilter with what constitutional requires as a minimum that the rules have to be read down in some way? But here, I may have misunderstood. I didn't understand you to be saying that there's any rule that prohibits the access to, transparency of justice principle from being applied. You're just saying they go as far as is necessary.
Right. And in the end...
But just to pursue the thought, one may have rules, as my Lady Arden says, that cast the balance between parties to litigation in a different way, but in a way which is itself compatible, not incompatible with that constitutional principle.
In the end, you can ask this question.
How about doing so
Yep.
at 2:00? Because I've let you run on for 5 minutes longer than you should have been allowed so to do, partly my own fault, because I asked you a question. And so I'll give you time to think out an answer, and we'll look forward to hearing you then. Court will now adjourn.